Greetings, dear colleagues, candidate, and the public. Today, on January 18 of 2025, the advisory group of experts has met in full to conduct an interview with candidate for the position of the judge of the Constitutional Court of Ukraine, Oleksandr Kopylenko. All 6 members of the AGE are present. Madam Secretary of the AGE, Maureen O'Connor, members of the AGE, Mr. Aleš Zalar, Mr. Vasil Shakun, Mr. Yaroslav Romaniuk. Member of the AGE, Madam Hanna Sukhotska, and I, Chair of the AGE, Oksana Vasilchenko. Also, deputy members of the AGE are present during the interview. Mr. Vitaly Makhinchuk, Mr. Volodymyr Kuzmenko, Mr. Marek Zubik, Mr. Richard Barrett. I would like to point out that we are working in a shelter, so in case of an air raid alarm, the interview will continue. I would also like to remind you that the interview is being recorded and broadcast live at the website of the Constitutional Court of Ukraine and at official pages of the AGE. I would like to draw attention of the members of the AGE and of the candidate to the fact that the use of sensitive data and information with limited access is restricted. If it is necessary to discuss such issues, the broadcast will be suspended. We are ready to start our interview, so I'm passing the floor to the Secretary of the AGE, Madam Maureen O'Connor, for a brief introduction of the candidate and reminder of the interview regulation.
Thank you, Madam Chairman. Greetings to our colleagues and those who are watching the proceedings of this advisory group of experts this afternoon. As our chair has already said, the advisory group of experts will now conduct an interview of the candidate, Oleksandr Kopylenko. Let me remind you that the opportunity for an interview is a mandatory stage of evaluating candidates as part of assessing their compliance with the criterion of high moral qualities. One interview is given approximately up to 1 hour, and the time limit for answering questions is no more than 3 minutes. Additionally, we ask all candidates to be concise, answer clearly, unambiguously, and to the essence of the question asked. At the end of the interview, the candidate can make a short final statement, no longer than 5 minutes. I would like to note that during the processing of materials about candidate Kopylenko, the advisory group of experts sent him questions to provide written explanations, so the candidate had the opportunity to prepare and provide answers. So now we have with us candidate for the position of judge of the Constitutional Court of Ukraine, Oleksandr Kopylenko, who was admitted to the competitive selection by the Committee of the Rada of Ukraine. He is a People's Deputy of Ukraine of the 9th Convocation, Deputy Chairman of the Committee on Foreign Policy and Interparliamentary Cooperation. He is a professor at the Department of Theory and History of State and Law at Koch University. He is a member of the Committee on Human Rights and Reintegration of the Temporarily Occupied Territories, 2019 to 2022. He was director of the Institute of Legislation of the Verkhovna Rada of Ukraine from 2002 to 2013, 2014 to 2019. Member of the Central Election Commission, 2013 to 2014. Advisor to the chairman of the Verkhovna Rada of Ukraine, 1998 to 2002. Scientist at the Institute of State and Law of the Academy of Sciences of the Ukrainian SSR, 1985 to 1990. In addition, I would like to remind you that Oleksandr Kopylenko already participated in the competition selection last year, but not passed the interview with the advisory group of experts. Mr. Kopylenko, if you would like to add anything to the qualifications that I just mentioned, please do so now within a few minutes.
The only clarification of my biography, which has no impact on the general course of my life. You did not mention my work in the legal management of Verkhovna Rada of Ukraine for 8 years, but I don't think that this is that significant. Thank you.
So colleagues, we will commence the questioning.
Дякую. Олександре Любимовичу,
Oleksandr Lyubimovich, participating in this competition, you confirmed in written that you are aware with the acts that regulate the activity of the advisory group of experts and the methodology that the advisory group of experts is using when analyzing the high moral qualities of the candidates. I would like to draw your attention to part 5 of the methodology that defines that the advisory group of experts can consider the fact of cooperations or lack of cooperation of the candidate during the procedure of evaluation in order to find out whether or not the candidate poses the reasonable doubt on his moral qualities or not. Tell me, please, what was your reason not to communicate with the advisory group of experts, mainly when the questions about the presence of the powers of attorney issued on your behalf or on the scientific papers? And I will explain what I mean. During the written inquiries, the advisory group of experts gave you the questions, requested information on the provision of the powers of attorney issued by the candidate during certain period of time. You indicated that no such powers of attorney you have. During the next round of questions, the advisory group of experts paid your attention that we obtained information about 10 of powers of attorney. And then again, even when the advisory group of experts paid attention to this fact, you still object the fact of existing of these powers of attorney. Can you explain why? I can say the same things that I already said. I requested the advisory group of experts in my first answers to provide me the information where they got this information, because I do not have this information. I requested twice to show me these powers of attorney. I can only now recall one that is not valid anymore about my damaged car, and I see no other sins after me. And maybe that's just my opinion. As for the text of the dissertation, thank you. You know, I really wanted actually to say this because I even spoke about this twice or 3 times. And my dissertation for the candidate has been defended almost 40 years ago, but since the advisory group of experts demands very clear, straightforward data, statistics, 1987, that's almost 30 years ago, and back then we didn't even know that there are computers or electronic texts. Back then, all dissertations, since it was another state, another epoch, all of them were sent to Moscow to the so-called Moscow High Attestation Commission. And the same about my dissertation in print was sent there. I don't know how they stored it after that. I don't know how it was stored in Kiev. That Institute of the Scientific Technical Information had the repairs at least 4 times, and they moved the Ukrainian High Attestation Collegium also moved, so I cannot really say. This is not my intentional reason, but that's just the way things are. And I was a bit surprised by the questions like this. My answer is more aimed at the foreign members of the ADG, because you and Vasil know about my scientific papers and you know about my contribution to our historic legal science. My 2 first monographs were published in 1992. No others were published before me. And if submission of the dissertation is fighting against pretended plagiarism, then I will tell you one thing. I was the only author of it. Because others would steal these things from me. I had no plagiarism. Also, I received the question about the form of defense of my dissertation as the scientific report. And I got very strange, unprofessional questions in the part that testified that the person who prepared these materials for the members of the ADG, they were not aware about this procedure. The defense of the dissertation in the beginning of 1990s, it was completely in line with the set procedure. Back then, it's also the public event or measure of the defense of dissertation with compliance of all procedures, but the only difference is that instead of text, the monographs were submitted that gained the general public appreciation. And these papers are my pride. They were recognized and rewarded by Hrushevsky a reward, and the laureate of such name or rewards had the right to defend their dissertations as scientific reports based on monographs. As for, and that's some one more thing, thank you, Oksana Vasilyevna. As for cooperation or lack of cooperation, I am very loyal to cooperation with the advisory group of experts. I would also wanted to speak about one more thing, and I wanted to bring it on in my concluding remarks, but I will say now, I see certain contradiction in understanding of the mandate of the advisory group of experts and the reality, since in questions that I got, there was a reference to methodology, and I am aware of it. I'm familiar with it, and my attitude to it, that's a different thing. But in my replies, I made references to the current legislation, and I think that any methodology, even the most impeccable one, and I have no doubt the professionals worked on it, but nevertheless, in accordance with the Constitution, it must be adhered to, and it has to be written based on and in the framework of our legislation. Thank you, Oleksandr. You got the question right about the cooperation of the advisory group of experts. The only thing I would like to indicate also for those persons who are listening to our interview, and that is that such mandate of the ADG is granted by the law, by the Constitutional Court of Ukraine, and the right to collect confidential information. You as the acting MP, you voted for such changes, such amendments to the Constitutional Court of Ukraine. So we act upon the set by current legislation method and in the framework of the mandate granted to ADG. I'm happy to hear this position. I voted for this law. But you know, as anecdote, when the citizens ask whether they drinking alcohol, but he says that he's drinking but with no pleasure. So I did vote for this law, just understanding the urgent situation that took place. And now you can see that these problems are actively discussed in the session room, and there are referrals to the Constitutional Court. There is a problem in place, and I will repeat myself one more time that I have the impression that you make references to methodology that cannot be contradictory to the law and must be implemented. Thank you for your position. It is vitally important for me. But I made references to the law that is of priority, in my opinion. Thank you, Oleksandr. Madam Hanna, please, your questions.
Yes, I also have a question, but I also have a question concerning cooperation with the advisory group of experts, because I am also a lawyer, constitutional lawyer, and I understand that when we have a constitution, we have a law, and then on basis of the law, we pass the methodology. It is everything coherent, and you are acting in the framework of the law. So for that reason, we can also put the detailed questions concerning our activity, our capacity. And now I would like to be back to the declaration, to your declarations, because in the declarations starting from 2020, you indicated that in July 2019, your wife acquired ownership of an unfinished apartment, namely an apartment with an area 76 meters in Kiev. And it was your behavior that in response to the advisory group's questions about providing evidence of the value of such an apartment and construction, etc., you refused, referring to the inadmissibility of storing, using, and distributing confidential information and personal data about your wife without her consent. But the AG group gave you information that will be, how to say, not public. And despite that, you also decided not to give answer to the advisory group of experts. So we would like to know now how is your position? Why you consequently in different situation, how to say, not give the answer and not cooperate with the advisory group of experts?
What is that?
You know, I disagree with the statement that I didn't cooperate. If the members of the AGG are not satisfied with my answers, it doesn't mean that I am not seeking to cooperate. My position remains unchanged. Collection of information about third parties, I think it goes beyond the mandate of the Commission. My wife, who does not subject to declaration, did not give me the permit to share this information. On the other hand, this apartment indicated in the declaration exists. It's not concealed, and the norms of the law have been adhered to. That's all. Nothing else to add from me. Oleksandr Lyubomovich, I think you wouldn't mind on the requirements of the anti-corruption legislation of Ukraine that your wife as the wife of the MP, and in accordance with the legislation, you are to specify information about her in the declaration. All information about her, I would say about her well-being or life with me, it has all been filled in the declarations that I have sent to the National Agency on Corruption Prevention in accordance with the law. And I wrote there the same information. This apartment is indicated there, and it said that my wife, who does not subject to declaration, did not provide me the consent to provide this information. All these declarations are in the National Anti-Corruption Agency of Ukraine, and I will repeat one more time that I didn't try to hide anything, and I'm not hiding anything. Oleksandr Lyubomovich, you also know the list of questions because the advisory group of experts sent to you these note once, and they are referring the compliance of the anti-corruption legislation requirements. And we would like to find out your opinion about the offense that was the subject of investigation by the National Agency on Corruption Prevention on the 8th of November 2021. The protocol was made about the administrative offense by you envisaged by Part 4 of Article 172.6 about the Criminal Offences Code of Ukraine, and you, as the subject of declaring as the MP, in violation of the requirements of the law, you have specified incorrect information in the declaration in 2019 that differ from reliable information. And in fact, the total amount was 473,793 hryvnias 55 kopecks. Clearly that the resolution of the Pechest District Court of Kiev, the proceeding in the case on bringing you to administrative responsibility for committing an administrative offense was closed, but closed due to the term of the due to the expiration of the term for bringing it to administrative liability. So, what do you think? This is the fact that was registered by the competent body, not by the ADG, right? So, do you think there was the fact of the administrative offense? And why didn't you show this amount in your declaration? If you don't mind, I will start with the end. Your words about the conditions or circumstances, you know, if I was up to the political repressions, you could speak about my rehabilitation, but let's start from the beginning, and I would ask you to go beyond the limits of staying laconic within 3 minutes, because I have to explain the situation very thoroughly. I would kindly ask the members of the ADG if they have time or will, after the end of this interview, to go a bit higher here to the crossroad of the street Bogdan Khmelnytsky and Kotyubinsky, where the legendary, well-known house of the writers, building of writers, is located, with the 30 memorial boards where the current Ukrainian literature operated and was born, including my grandfather, Oleksandr Kopylenko. I am still residing in his apartment in this building. There is the memorial board dedicated to him. And this whole situation is caused by my sincere, I would even say maniac, desire to preserve the national memory and our home, our building.
That's why my sister and I had an idea, and since in our building we have a shelter, I do not want to talk about it in more detail because this is the issue of national defense. We have a shelter there that before the war was not used, and we had an idea. Back then we called it a basement, not a shelter, and we had an idea to make a museum. And other residents of our house, our building, supported me. Of course, there are almost no heirs of literary geniuses, but there is a group of enthusiastic citizens. At the same time, the citizen mentioned in documents of the NACP and mentioned in your questions as well, and whom I knew as a diligent employee of the Cabinet of Ministers, suggested to me to make all necessary bureaucratic steps to get a permission for this museum. For that, I transferred funds in the amount that is specified there, and no one is hiding anything here as well. But unfortunately, as it happens in such cases, even experienced people may become victims of fraud, and he was such a fraudster, and he had no intention to realize our arrangement, and he just stole these funds. And at the very beginning, he provided inaccurate information to the notary who was preparing all of this arrangement. So that is why there emerged a dispute. He started challenging the enforcement proceeding, and I had to submit a report, an application to the competent bodies, and in particular, there was initiated a criminal case against this person, and together with my sister, we were recognized as affected parties. Since there is a dispute, and since the other party had no intention to return this money, and since the very beginning I was a victim of a lie, I took into account the explanations of the NACP, according to which in such instances when there is a dispute without a specific court decision, and without completion of the criminal case consideration, that was a disputed asset that until the end of the proceeding was not specified in the declaration. The NACP had another position. They considered it not from the perspective of the dispute, but from the perspective of my mistake. And because of that, this protocol was prepared. But similar protocols are not the end for the NACP, and that is just the start. And the court says the final word in this instance. And since the court case started in 2021, and then the war delayed all court considerations, it happened that the term for the consideration of this case expired. I would like to refer to an explanation of the High Administrative Court, according to which, under similar situations, the guilt is not established, but the case is closed with respect to the expiration of the term for the consideration. That is why I would say this nice word rehabilitation, but in this case, this is not very appropriate. Mr. Oleksandr, I was not asking about $250,000 with respect to which we have information in the Unified Register. I was asking about the amount that I mentioned, and that is about $20,000 of your sister. I'm talking about this protocol. These are completely different proceedings and different amounts. Microphone. Sorry. There was no proceeding at all in that situation. In 2020, while studying my declaration, the NACP was doing that. The NACP was satisfied with my explanations, and the final report on the check of my declaration for 2020 was saying that I did not have any unjustified assets, any conflict of interest, and any other problems for which a person could be brought to responsibility. Of course, we are not discussing the fact how you spent this amount. That's absolutely correct, and that is congratulated and welcome to commemorate your well-known grandfather. I'm talking about the fact that once you receive these funds as a People's Deputy of Ukraine, as a person who acts in the interest of the state during entire lifetime. We are asking why didn't you reflect that in the declaration? I'm not saying that there was a violation. I'm asking why you object against the fact that you received these funds and the fact that it was necessary to declare them, since you disposed of these funds. You were acting in the interests of your grandfather, of the society, of the residents of this building. The fact is that you are objecting against the fact itself. Thank you for good words addressed regarding our neglected culture. I'm really grateful to you for that. I would like to emphasize that I'm not objecting against this fact. It's impossible to argue against it. Money transferred by my sister for the organization of this museum. I just explained why it was not declared, because it was a disputed asset with respect to which the court proceeding and the criminal case were ongoing. With respect to those funds transferred by your sister, there was no criminal case. That's another amount. No, with respect to this asset, there was a criminal case. With respect to fraud and lie. There is a surname and specific number of this criminal case. That huge amount that you are naming, with respect to it, there were no proceedings. There were explanations which I provided to the NACP, and the NACP was satisfied with these explanations. And I would like to repeat again that the NACP did not find any unjustified assets or any other things that could entail responsibility. We are talking right now about these funds that were allocated for the museum that was planned. Okay, clear. Thank you for your answer. Again, we are talking about declaration. We are talking about the fact that during a long period of time, for example, from 2015 to 2019, you as the person obliged to declare your income, in none of your declarations you specified bank account, but we understand that you as a civil servant received salary to a bank account. But again, we are not talking about significance. We are talking about diligence with respect to that fact that you systematically failed to declare this information. What is your position? Why did it happen like that? Well, I have such an impression that I am guilty without guilt. The matter is that I have no bank accounts even now. I have an account in Privatbank where I receive my salary, and one more account to which I receive my academic payments for the title of the academician of the National Academy of Sciences of Ukraine. For a long period of time, salary was given in cash, and that's not a violation because even now cash is a normal system of money flow. Back then, when we moved to cards, then my accounts became reflected. Of course, for me it's quite strange, and I said that in my explanations as well. Why is the salary account considered as something complicated and controversial? But again, I would like to say that for a long period of time, I received a salary in cash, just like other employees of our institute. And by the way, I also received these academic payments in the cash desk of the National Academy of Sciences until everyone moved to this cashless system. Mr. Oleksandr, the question is that each of these violations related to declarations, like failure to declare bank accounts, failure to declare funds transferred to you by your sister that you disposed of, failure to declare your participation in civil society organizations, quite well known, and like European Academy of Constitutional Law. I can also mention the civil society organization, EU Parliament Institute, the Ukrainian Institute of Study of the Russian Aggression, and other NGOs and CSOs. The question is that such numerous failure to comply with the legislation gives rise to questions for the candidate for the position of the judge of the Constitutional Court of Ukraine. In your opinion, do you think that the law violates the Constitution, or maybe you had some other reasons why you failed to declare as it should have been declared according to explanations of the NACP? I do not want to name it as some conscious negligence of those provisions that exist. There are specific situations. For example, for a long period of time, I did not have even salary account because I was receiving my salary in cash. And once the National Academy of Sciences of Ukraine moved to the use of the cashless system, I started declaring my accounts in the declaration. That's not some intention, that's just reality reflected in the declarations later on. When I did not have an account, I did not have it. Once I had it, I started declaring it. With respect to this asset that we just discussed, as I've said, I provided my explanations in writing about that. That was a disputed asset, and according to the explanations of the NACP, until there is a decision under the criminal case, it was considered as a disputed asset. And I was governed by this consideration and not by my desire to violate something. And finally, with respect to civil society organizations, yes, I saw these comments, but I would like to say the following. Two civil society organizations are registered, but they did not start working at all. They do not have accounts, seals, anything. It was just an idea, some desire to register them. We are talking about the European Academy of Constitutional Law. It's a good name, and I'm also talking about Ukrainian Institute for the Study of War, but everything remained at the stage of registration of charters, and that's it. With respect to a new Parliament Institute organization, on the contrary, it was registered. This organization was registered about 15 years ago, and for the past 8 years, it has not performed any activities. So, to declare these non-functioning organizations, I was governed by the consideration that it is necessary to declare when they do something. For example, I declared my membership in the charity foundation, and we actively work, so I declare it. Thank you. Maybe again, the AGE. It is important for us to understand the motivation, why there are some requirements of the law, and we want to know about your motivation, why you did what you did. In particular, with respect to declaration of family members, when your children were underage, what was your reason not to declare your children who were living with you, as far as I understand? That's not very accurate. I think only in one declaration I did not declare my minor children, but my eldest son lives with my wife from the first marriage, with whom we divorced long time ago. But he is registered in my apartment, and I'm pleased that there is a new generation that will continue this. But he lives with his mother, with my ex-wife. At that time, my younger son lived not with me, but with a grandmother in her apartment. So again, I had no intention in that, and there is no intention at all to violate anything. I'm a diligent citizen. I'm being governed. In the past, I was undergoing internship in the American Congress in 1996. I was really impressed by that. I learned many valuable lessons for me, for my activities in the parliament. And one of the congressmen said that our American principle is that if you want something and you cannot do that, you still cannot do that. So I'm being governed by this principle. If there emerge some issues related, maybe a lack of attentiveness, maybe to the character, but still, it does not influence the overall attitude and the need to comply with the law. Oleksandr, again, with respect to inattentiveness. We all understand the current conditions in the country, and it's quite logical to receive the question from the AGE about crossing of the state border of Ukraine. That's the question that civil society organizations are interested in and the public is interested in. That is the established fact that you crossed the state border of Ukraine. During the round of written questions, you objected this obvious fact. And why did you do that? And why did not you inform about the grounds to cross the border? I mean, starting from 2022. I will be frank with you, it infuriated me. Why? I do not understand this heightened attention to trips abroad, which are made according to instructions of the chair of the parliament, which are made by the person who is not on military registration, that is me. And foreign trips are a part, among other things, of our work as deputies. Why I said that it was not accurate? Yes, I'm insisting on that. I received the list of my trips, but sorry, absolutely inaccurate list, because one trip was counted as two there, and there you have such a long list. But there was mentioned a trip there and a trip back. I was surprised by that, frankly speaking. And I just wanted to draw attention to some lack of diligence in these questions. I can say again, all of my trips abroad were made as business trips, based on instruction of the chair of the Verkhovna Rada, without which I would not be able to leave Ukraine. And I don't want to talk about that, but since we are being frank here, in August of 2023, I was in a serious traffic accident. I barely survived. By the way, I became a victim of doctor's mistake. We we cannot discuss this information. No, we are talking about that. I'm not showing you some specific injuries and diagnoses, so we can talk about that. So I had trips abroad, in particular to Germany, for treatment and medical consultations. But again, according to the permission of the Ministry of Health of Ukraine, without which I could not go anywhere, and being on annual leave. I was also surprised by this question when the AGE started demanding some certificates from me. I think it's not appropriate. Mr. Alexander, we are talking about the purpose. That's why we have this written round of questions and then the interview. We are trying to find out these facts. And if you provided the AGE with the instruction of the chair of the parliament, we would not ask these questions about these trips abroad and about the reasons why you traveled abroad as a People's Deputy of Ukraine. That's why we were asking about that. And if you allow, we will continue this pool of questions. So you crossed the border. There is a recording of vehicles with which you did that. And it's obvious that there emerges a question. Were you obliged to declare the use of specific vehicles? I think I should not mention all of them because that's quite a significant number of them. Again, in this case, do you understand why are you not reflecting the undisputed facts in official documents?
I do not deny my trips abroad, but I think that in certain situations the AGE allows the excessive interference into the personal life. As for the logics of crossing border using different cars, I traveled by bus twice abroad, and maybe I also had to declare my right to use the bus from this logics. Take into account the martial law, the problem of logistics, the absence of direct routes and flights, of course. Of course, I use just the situation when people would go in this or that direction, that would just take me as a passenger. So to reflect a single trip and reflect it, I think that's a nonsense. And the same refers to the instruction of the chairman of the Verkhovna Rada of Ukraine. I had an open understanding that without that instruction, I wouldn't go anywhere. You see that all social media, mass media, they are filled with information about the way people who do not have the official permits, they cannot go anywhere and they just made to go back. Actually, you answered the question yourself. Why such thorough attention to border crossing is dedicated? And here I would like to say that the advisory group of experts was only specifying those cases where you were as a driver of the car. We did not ask about all of those trips. I have never crossed the border as the driver. This is not true information. I haven't been driving myself for the past 5 years, given the traumas and injuries that I had, especially after my car accident. So this is not correct information. Alexander Volodymyrovich, Madam Hanna, please.
So I am listening to the discussion because it's difficult to say that it's an answer and question session, because we put answer and we put question and you...
Вибачте, будь ласка, одну хвилину.
I beg your pardon. I beg your pardon. I can't hear the interpretation.
Now it is working.
Що?
It is working. I hope that it works. But you know, we are sitting
Що,
here.
міняємо, да?
Yes, always. I see that it is about.
Так, чутно, спасибі.
Now he can hear.
Yes, we are sitting about 50 minutes, I think, and we discuss the different issues, but it is rather a story and history, but not answer to the questions. We, as advisory group of experts, we are rooted in the law, and we have a right to put the question and receive information. And so for that reason, I also once again try to be back to make a question and expecting answer from you, not the whole history. It is a problem concerning the court case on loan repayment. It was, how to say, according to the Unified State Register of Court Decisions, your sister was a plaintiff in the court case for the payment of a loan in the amount of US $250 on the basis of an oral agreement dated March 2012. It is known from the court decision that on February 2020, an agreement on the assignment of the right of claim on this loan was concluded. On May, 1 year later, 2021, the Shevchensky District Court of Kiev dismissed your sister's claim. In response to the question of the advisory group, you stated that you were not aware of this court case. Also, you did not answer whether you were the original lender on the basis of the loan agreement dated March 2012. On November 2024, you got acquainted with the materials collected about you by the advisory group. Therefore, you are familiar with the photocopy of the letter of demand you signed dated February 2020 on the return of funds to you under the oral loan agreement dated from March 2012 and in the amount of US $250 provided by the National Agency for the Prevention of Corruption. Why, whether you were you have to inform us whether you were the original lender on the basis of the oral agreement dated March 2012? If so, why did you not declare this loan as an asset in your declaration until 2020 inclusive? Because we would like to know something more about you because your declarations are completely, how to say, unclear. And we would like to put you clear questions and expecting clear answer.
I'm answering the questions the way I think I should answer these questions. And second, I want to say one more time that this question has been investigated thoroughly by the NACP in 2020. And according to the results of the check, no questions were to me. That's all I want to say. According to the results of the check in 2020 and my declaration, the NACP have admitted that I do not have unreasonable assets, that I do not have facts of illicit enrichment, and no other things related to it. As for my declarations are clear and straightforward, and they give answers to those questions that I am obliged to answer in accordance with the law, and they all have been submitted in timely manner. 2 of them were verified in 2019 and 2020. I don't know how it will happen in the future. Of course, if they have questions, as a conscious citizen, I will answer these questions. And dear Madam Sokotska, could you please explain what is not clear in my declarations?
No, you did not declare this loan as an asset in your declaration until 2020 inclusive? And what is the source of origin of the specified 250 US dollars? You did not explain it.
Я можу повторити
I can repeat one more time that it is a strange situation from the point of view of the current dialogue about it, and it's unclear to me and unpleasant, I should say. But I can repeat myself again. This situation has been analyzed, investigated by NACP that have recognized and admitted that the explanations that I have provided are satisfactory, and due to the results of consideration of my declaration in 2020, they had no claims against me.
I didn't receive a good answer, but I have no more questions because I don't receive answer.
Олександре Любомовичу, ну знову таки.
Oleksandr Lyubomovich, there is the inquiry to the advisory group of experts, and we are insisting in line with the mandate that is granted to us by the current legislation. Mainly, there was the inquiry to the by the AGE to the apparatus of Verkhovna Rada of Ukraine about the car. You have denied in the written round of questions that you were using this car, and you don't even understand what is the essence of question. But the reply of the staff of the Verkhovna Rada of Ukraine was that you indeed contacted the staff of the Verkhovna Rada of Ukraine about the car Škoda Kodiaq to get the permit to go to the territory of the Verkhovna Rada of Ukraine. So what is the reason for you when you deny the obvious facts? I mean, if you have you as an MP requested this car for your use to go to the territory of the Verkhovna Rada of Ukraine, but when the AGE is asking you about this car, you deny the fact of using this car. Can I answer the question? I disagree with you completely in this. Sometimes I have the impression that you just can't hear my explanations, and that we are just moving in parallel. You ask me the question, I answer the question, but we cannot hear each other. I have answered already twice in relation to this situation. Well, first of all, in accordance with the order that refers to the pass of the MPs, there were never any limitations. It's enough to have the official document testifying you're an MP. And I also wrote you, and when you say that as of 2019 this car is in applications by me, that's absurd. This car was purchased by husband of my sister in 2021. By the way, in order to avoid any further questions, it's a well-known fact, but I do not disclose information about third parties, but the husband of my sister, he's a very famous person, the professor of medicine, and I don't think that you should doubt or have doubts about his income. I am not denying, and I didn't deny the fact that I have transferred from one committee to another committee, from Committee of Human Rights and the Occupation of Crimea. And I'm, by the way, the head of that department wrote you the letter that I didn't see. And I moved to transfer to the Foreign Affairs Committee. These committees are in different buildings, and I had to deliver my belongings that I have accumulated. I did not want to abuse the official car. My car was damaged not because of my fault, and I requested the husband of my sister to lend me for one day his car so that I could bring all of my belongings to the new address. And since I had to go to the territory, I had to enter the territory, and maybe there's certain bureaucracy, but this was a one-time trip. But I'm surprised that for so many years it's like the crimes against humanity that this document for one time to enter the territory is always following me around. And I should underline one more time that the MP is using the official card to go to the territory of the Verkhovna Rada of Ukraine, unlike some closed territory, and not to do it in front, using some back door, not to do it in the open space or in the public. That's all. Madam Hannah, do you have any other questions?
It is a question regarding the audit of the accounting chamber. Are you aware that on October 2022, a member of the accounting chamber sent a conflict of interest notice to the National Agency for the Prevention of Corruption, which contains information about you as a former director of the Institute of Legislation of the Verkhovna Rada of Ukraine? According to the information provided by the advisory group during the audit, at the request of the control group dated January 2022, an audit report of the planned internal audit of the activities of the Institute of Legislation of the Verkhovna Rada of Ukraine was prepared on the topic assessment of the effectiveness of scientific and scientific organizational activities, as well as the use of budget funds by the Institute of Legislation of Verkhovna Rada for period 2019 to September 2021. Are you aware of this report? Have there been any cases when you, as a director of the Institute of Legislation of Verkhovna Rada, set yourself allowances for high achievements in work and for the performance of particularly important work in the amount of 50% of the official salary, additional payment for a scientific degree in the amount of 10%, without a decision of the chairman of the Verkhovna Rada of Ukraine, as provided for by the resolution of the Cabinet of Ministers of Ukraine, by the law in Ukraine? So it is a question I would like to ask you. They are very important for us also.
Ви знаєте, воно важливе.
You know, it's also very important for me because this is a pure provocation, and there is a clearly determined procedure of preparation and approval of the reports by the accounting chamber, mainly the audit of the accounting chamber, that envisages also the acquaintance by that official who is being verified and them providing explanation, considering this report at the meeting of the accounting chamber and voting for that report. Nothing like this happened. I was not familiar with the initiation of this audit. The accounting chamber did not consider it and did not approve it. It's not clear to me how this situation has occurred. I learned about this seemingly audit only when I got questions of the AGE, and I can state one more time that this matter was not considered by the accounting chamber. I was not called up. I was not familiarized with these unclear results, and the report of the accounting chamber wasn't voted for and wasn't approved. As for my possibility to give myself some kind of sorry, you're also using some wrongful information, since to get some allowances for the scientific degree is decided by the resolution of the Cabinet of Ministers, and it doesn't matter just how much I want to do this. I cannot initiate this for me. I cannot set it for me because it's only based on the resolution of the Cabinet of Ministers of Ukraine. As for the possibility to give me other kinds of additional payments, I have to say that I have always conscientiously complied with the budget discipline. And on the other hand, I want to say that in honor of our apparatus and management, at least 5 times a year, our institute has been inspected by the control service of the staff of Verkhovna Rada of Ukraine, and decisions on the additional payments, bonuses is always correlated with them. And even if I even had these bad plans on my mind, I would not be able to put it into practice. But I want to repeat again, I checked the author of this thing, and that's a well-known person who has been writing these claims against all of their colleagues in the accounting chamber, so I'm not surprised at this.
The report, you read the report, so you were familiar with the context and text of the report.
Вибачте,
Sorry, no. I saw the text when I received the letter of the AGE. This was an absolute unexpected thing for me, and that's what I have just told you, that I have known nothing about this report. Only when I started answering the questions of the AGE.
Adopted by somebody, yes, it was official report, not only private report of one person.
це був приватний
This was a private report because it was not discussed at the meeting of the accounting chamber, that it hasn't been approved and not voted for. Nobody knows about this, and I haven't been familiar with it previously and never made my remarks. So I understand this is exclusively the initiative of the person who did this. I don't know what grounds they had to do so and what they had on their mind.
Thank you. I have no more question.
Шановні
Dear colleagues, do you have any other questions to the candidate?
Yes, I have a question,
Okay.
будь
if
ласка,
I
пан
may.
Yes, please, Mr. Alish.
I would like to ask the candidate whether he can tell us if he was the original lender under the oral agreement dated March 24 from the year 2012, where there was a sum of $250,000 included in this land agreement. So whether you was original lender.
I can answer only what I answered to Ms. Sukhotska, and I'm saying the same to you. That's not an easy situation. It's not clear to me, it's unpleasant to me, and of course it looks very strange. But with respect to this, I provided all the explanations to the NACP, and my explanations were satisfactory for the NACP. And pursuant to results of consideration of my declaration for 2020, they had no criticism regarding me.
Answer my question with yes or no. Were you original lender of $2,500 US dollars?
Я від
I answered the way I consider it as appropriate to answer. I will not provide any other answer.
Okay, thank you.
I have a question. Okay. I want to draw your attention back to the beginning of the conversation, and it has to do with the the power of attorneys. And your answer or non-answer to that confused me. So I want to confirm that on November 26, 2024, you familiarized yourself with the materials that were collected about you by the advisory group, including data on these power of attorneys. That's an accurate statement, is it not? Yes or no?
я вважаю, що ні, оскільки я просив дорадчу групу.
Microphone. Yes, sorry. I believe that no, because I asked in letters to the AGE It was said that the AGE has at its disposal information at least about 10 powers of attorney. I knew nothing about that, and I asked the AGE to tell me in more detail about that, but unfortunately I did not receive the answer. I can tell you again that I recollect only the old power of attorney for my destroyed vehicle valued at $1,000, and that's it. And unfortunately, I have not received this information about the specific powers of attorney that you are talking about.
And let me remind you, according to the methodology, the applicant, yourself, has the right to review all of the materials that is being relied on by the Secretariat and thereby the advisory group of experts. And on November 26, 2024, you reviewed your entire file, and in that file are examples, are copies of 10 powers of attorney. Are you telling me that those were not your powers of attorney?
У мене є
I have the list of documents with which I familiarized, and it did not include these powers of attorney.
You didn't see them there, or you didn't read them, or what are you saying?
я можу
I can show you the list for which I signed and which was showed to me by the representative of the Secretariat who was familiarizing me with the materials that have been collected with respect to me.
я би його взяв з
I would bring it with myself, but I did not even think that it would be necessary. Mr. Oleksandr, I would like to remind you that the list of these powers of attorney was there when you were familiarizing yourself with the case materials. I did not see that. Okay, thank you. If it was there, then I would probably know that, and probably this unpleasant discussion would not happen right now. May I ask one question to you? Tell me, please, what do you mean by these powers of attorney? What scene can I do when I'm entrusting something to someone? Mr. Oleksandr, we are not talking about scenes here. First of all, we are talking about cooperation, about willingness to coordinate with the AGE, because we understand that a person who is a candidate for such a high position, that is a judge of the CCU, has to be more transparent for the society than an ordinary citizen. That's first answer to your question. And secondly, we are talking about the fact that these are facts that are established and that are given in the list of powers of attorney. I asked to show these powers of attorney to me. Unfortunately, I did not receive information about that. I have the list of documents, and with respect to cooperation, I will allow myself to tell you. I'm sincerely open to cooperation with the AGE, but I have a persistent impression that we do not hear each other. You want to get only that answer that you want to get, and I am giving those answers which I believe to be appropriate. And I'm sorry, but I have a persistent impression, and I want to say that at the very end, that there is some third power that is influencing, that is referring the documents, that is preparing, translating documents. By the way, that's a question about transparency in activities of the AGE, and I would ask you, if it's allowed by the methodology, to pay attention to that. Thank you.
Sir, I want to bring your attention to the $250,000 loan that was subject of the court case. You lent the money to your sister. You say that it was reviewed by the National Agency for Prevention of Corruption. Unfortunately, while we respect what that agency does and respect the contents of their documentation of questions, it is for us to independently review. And that report is but one piece of evidence for us. It's not a complete answer to our questions. We don't accept, because there are some facts that are established that may not have been known at the time to the agency. I'm not saying this agency, but in general, that become known to us that were not known at the time one or more agencies did their report. So I want you to understand that we're not going to rely on the National Agency for Prevention of Corruption's report, and we're going to start fresh. Did you lend your sister $250,000, and then there was a court case that resulted on the repayment, for the repayment of that money?
Я можу сказати те, що
I can say what I already said several times, that the NACP, as the law enforcement body aimed at considering such situations, considered this situation, and they had no criticism regarding me. I cannot anything else.
Understand that answer. We all understand that answer, but that's not good enough, all right? That is a non-answer for our purposes. So all you have to say is yes or no with regards to the $250,000. Now I'm going to ask you again, and then it'll be the last time. Did you lend your sister $250,000, and then it became the subject of a lawsuit?
я так
Similarly, lastly, I can answer that that's not a very easy situation. That's unclear maybe for your situation, but again, I'm referring to the decision of the NACP.
I have to take that as a non-answer.
Шановні колеги,
Dear colleagues, are there any other questions to the candidate? If there are no other questions to the candidate, Mr. Oleksandr, you have up to 5 minutes for concluding remarks. Please, the floor is yours. You know, I will not spend all 5 minutes. I'm satisfied with our conversation. Thank you for providing the opportunity not only for answers but also for discussion. Each of us has own perspective on specific problems. Regardless of the result, it has been interesting experience, and I hope I will come back to it, and I'm wishing good luck to you. Thank you. Thank you, Mr. Oleksandr, for your answers. Dear colleagues, dear public, now I'm declaring interview with candidate for the position of the judge of the Constitutional Court of Ukraine, Kopylenko Oleksandr, as over.